The Supreme Court is currently mulling over a few cases that could reshape the country as we know it, including one that asked the question, how easily can police seize your property and hang on to it?
That is the center of Coley v. Marshall, all surrounding civil asset forfeiture. In 2017, Halima Coley bought a car for her son. A few years later, her son was pulled over and weed was found inside the vehicle. Police impounded the car, which Halima owned, and her son was arrested. Now, although she was never charged with any crime, the police held onto her car for months.
Alabama state law allows police to keep the property it seizes while a forfeiture action proceeds through the courts. And it's a process that could take months or even years.
Let's bring in Queen City News Chief Legal Analyst Khalif Rhodes.
And Khalif, you've had experiences like this as a lawyer yourself. What kind of precedent is out there with this on her side?
The irony is this took a long time, 20 months to get her car back, and the process is exactly as you guys explained. There has to be a hearing to determine, well, should you get the vehicle back? North Carolina has very similar rules and laws in place. If you aren't charged with the crime, if you're the victimless defendant in this case, then typically you get it back. But COVID, obviously, 2019, I could assume that was something that prolonged this process. But the precedent is kind of murky. This case, after she got it back, she still was frustrated by not receiving her car, what she believed was in a timely manner. And so she filed claim. District Court dismissed it. Court of Appeals dismissed it. And so she finds it in the Supreme Court. When I listened to the hearings today, it's kind of telling how the judges, or justices, I should say, kind of tip their hat on how they feel. Supreme Court Justice Thomas, you can see that he does not believe that this case should even be there, let alone want to side with the petitioners. But Sotomayor, seeing that the argument was kind of failing, she kind of threw him a life raft and said, okay, so what you're attempting to say is X, Y, and Z. And he was like, yeah. You can see at that portion that the attorney recognized he had at least an ally through her. As they go through their arguments, they'll tip their hats on where they kind of lie. I can see it depends on where the argument of what test they want to use. If it's a speedy trial argument, I believe that the court will find that this case kind of was, like the district court said, should not have any pairing and they shouldn't go forward. But if they do a due process analysis, which I believe they should have done in the first place, they'll send this back to the lower court and say, go through a due process analysis and make a determination on if their due process rights were violated. And it seems like there may have been something that there was a violation. There's not a time frame on it, but there was a hardship, there was a burden. This person lost her job because there was not a vehicle. Those are things that we want to avoid. We don't want to create a system where you're taking property from a person just in forever, indefinitely.
And when they weren't even involved in that crime to begin with. So what kind of shot does she have to win here, whether it's in the Supreme Court or if it gets kicked back down to the lower one?
The Supreme Court, I think, sends it back ultimately and says this case is one that the lower court should establish and adopt the due process argument. If they do that, she will ultimately win. If the court says, you know what, this is a speedy trial argument, I think it goes back and the lower court just reaffirms what they said before, that look, they were within their right to take as long as they needed to. And because of outside circumstances, COVID being one of them, there was no violation at all. But if I'm a gambling man, and I'm not, I'd say that this one goes in her favor at some point.
All right, so we'll just have to wait and see, Khalif. Thank you.